And we begin. Ladies and gentlemen, good afternoon, good evening. Welcome to this marvelous launch of a very thought-provoking, inspirational book by Advocate. Advocate, how are you?
I'm fine. Thank you very much. How are you, Freddie?
I am good, Advocate. It's good to see you. I hope you are in good spirits. I hope you've had a good lunch, because we are about to get into the launch of your book, and we are also about to get into some serious discussions.
Yes, I did have lunch. I'm not sure if it was good, and I've got water here to calm my nerves.
Keep that water glass very, very close, Advocate. I'm sure somewhere in the middle of this discussion, you are going to need to take a few sips. I see we have people that are still joining, but it's okay. We can actually start, and they will join us, and they will find the discussion proceeding as we go. So for those that we have lost, for those that have passed due to COVID-19, we're just going to take just about 15-second moment of silence that we are going to observe, so that we can be able to pay homage, give honor in recognition of the souls that have departed, and then we'll be able to start. May their soul find rest and eternal peace. So good evening again to those that just joined us. My name is Freddie Mohotlani. On behalf of the Mpumalanga BMF, will be your facilitator for the book launch. Those that don't know which channel they've logged into, we are here to launch the book Land Matters, South Africa's Failed Land Reforms and the Road Ahead. At this stage of our 27-year democracy, it has become unmistakably clear that the idea of a rainbow nation and imagined South Africa that belongs to all who live in it is a fleeting dream that many citizens have woken up from or are waking up from, while the idea of redress to achieve equity remains the subject of debate, political bargaining. The equity gap grows bigger and bigger every day, and with it, the inequality and the unwillingness to reform. Even the legislators that agree that there is a need for the amendment of Section 25 of the Constitution differ significantly on its implementation, which seems to be the goal. As Advocate Thembeka Ngcukaitobi stated, it is wrong to think of land reform as a destination. Rather, we should think about it as imagining a world and being in it. The very idea that South Africa belongs to all who live in it, even just the word belong, it has become almost an oxymoron in our lifetime. Because while we say it lightly as a saying that we have, that South Africa belongs to all who live in it, the truth of the matter is the majority of the South African land, the participation in the South African economy belongs to the few among us, while the many among us are not necessarily participant in a productive way of this. So with that being said, we have a very brilliant advocate He's here today to address us about this same matter. And I would like us to challenge him as much as we can. But before, Advocate, I give you an opportunity. I'm going to give you a whole half an hour for you to take us through the book, your thought process, the motivation, and what you hope that this book would inspire in everyone and point us to which direction. I just want to acknowledge a few people. Each and every person that is here, I welcome. You are more than welcome. We appreciate you being here. This will not be possible without you. Advocate, I've got a few of your colleagues from the legal fraternity. I see Advocate Lakim Konto is here. I see one of the senior partners of Gronier Dival and Skosana, Mr. Sandile Skosana, is here. I see Advocate Temba Kininda is here. I see the founder of Ngumalo and Greens, an associate, Ngobile Ngumalo is also here. I hope I haven't left anyone out from the legal fraternity. I see those from the political fraternity are here. I don't know why, Advocate, you seem to attract the red overalls a little bit more. I'm not sure why, but I see the left and then I see the far left. And then I see that they are here in their very big numbers. I can see a lecturer from UNISA is also here from the academic fraternity. And I can see associate professor is also here from UNISA as well. They will be, so I'm telling you this, Advocate, so that as you address us, it gives you an idea as to what audience you are facing and what audience is going to be challenging or rather asking you questions with regard to this. The last thing that I just want to say, I can also see two people from royal families, from the chiefs are here. That's going to be interesting because there's a chapter called Chiefs and the cattle that was stolen in the book. So, and it's indebted. I see there's one from, what is this place here? From Matatiele. I can see another one from up north in Limpopo. So yeah, I can see that there are people from the chief lineage as well, who are also holding some of this land, Advocate, that we are hoping to talk to today. So without meaning to leave anyone out, I acknowledge everyone that is here. I appreciate you being here. I pray that we are going to have a productive session, that we are going to engage, and that as we give Advocate this time to address us, we are going to listen to what he's saying so that when we start poking him, it would be for things that he may have neglected to address or areas where we feel that he was not clear. Advocate, I went and looked for reviews. To be honest with you, I went and looked for critics. I was not looking for reviews because I knew that there would be too many people who are from the left in terms of our political spectrum. So I went to look for some people that would have critiqued from the University of Cape Town, the Institute of Poverty, Land, Agrarian Studies. I found a piece that was written by Professor Andries du Toit on the reviews of land. I also found another piece by the Daily Maverick. I'm not sure who wrote the one in the Daily Maverick, but I also found one in the Daily Maverick. And to my surprise, instead of critiquing, they were singing praises. And it defeated the purpose of what I was trying to do, because I was hoping to find some far right ideologies that would be trying to poke holes in it. So I hope that this means that as a country, as a nation, we are being steered in the right direction. But both of them, if I can just tell you a few passages, they are saying a very thought-provoking and progressive way of looking into the redress and the issue of equity as opposed to just equality. The other one say, Advocate Ngugai Tobi tackles the issue of land. And in fact, the Daily Maverick review, when it starts, it says, do we really need another book about land after all that has been said? So I went into this review with a little bit of excitement, hoping that I find some fireworks, but there was consensus in most of the review, except maybe the one criticism that they had was that your vocabulary was very difficult and philosophical in nature. And he said he had to read this book with 3 pages of Wikipedia open, just so that he would be able to double check the meanings of some of the words that you use. So without any further ado, ladies and gentlemen, we are just going to give half an hour to Advocate Tembeka Ngugai Tobi for him to address us. By the way, his name is Tembeka Nicholas Ngugai Tobi. He's 44 years of age, and he was born in Cape Town. He's a lawyer, a public speaker, an author, a political activist. He's a member of the South African Law Reform Commission. He authored the book, The Land is Ours, South Africa's First Black Lawyers and Birth of Constitutionalism. His interests are history of constitutionalism, Black intellectual thought, land, and he's the author of 2 best-selling books. And today, we are going to look in depth into this book, which is his latest offering. And what I love about this book is, Advocate, it took me to 1665. It took me to 1873. It took me to the United Nations in 1973. It took me to 1993 during the Codonia negotiations. And it brought me all the way back to 2020 and 2021. So I am well traveled. After today, I will take 2 days nap because this book has been my pillow for the last, at least for the last 2 weeks. So ladies and gentlemen, welcome. Advocate, take it away. The floor is yours.
Thank you very much. I am very pleased that the Black Management Forum has invited me to speak tonight. I'm also very pleased that we have so many people that have turned up to participate in this conversation about land, at least as discussed through Land Matters. I think this is my 3rd time that I've come to an event of the Black Management Forum. The last time I actually spoke about land, I was on a land panel. And at that stage, some of the ideas in this book were being developed, and I was debating them with different people. And I debated them with people at the BMF then, and those who were in that conference at Gallagher Estate will see some of those ideas much more refined now, because I think it was 3 years ago, because my own thought process has evolved over time. So tonight is an experience that I look forward to. I thought what I would do is to spend just 5 minutes just explaining what the book comprises of, and then to spend the rest of the 30 minutes that I have dealing specifically with the issue of justice and equity in compensation, which has attracted quite a lot of attention in the South African public imagination. So the book Obviously, as my style of writing, for those who did read my first book, starts off with a historical account. The period from which we start is 1647, and it would be notable that it's not 1652, but it's 1647. Now that's largely because that was the arrival of a first group of Dutch settlers who came via a ship called the Haarlem. And they had a shipwreck, and some of them were then rescued, but others were not. They stayed behind. And another ship that was then sent to assist the survivors of the Haarlem included a man called Antonich Januzen van Riebeeck. We call him Jan van Riebeeck. He first arrived in 1648, and he stayed for a period of 4 weeks in the Cape, in which he could scout the area, witness the area. When he went back to Holland, him, together with one of his colleagues, wrote a letter to the Dutch East India Company. In that letter, they proposed the establishment of a settlement in the Cape. Now, this idea of a settlement struck the local Khoi people as a bit odd. You see, the Khoi people of the Cape knew of the Europeans. They had met the Dutch, they had met the Spanish, they had met the British. But they never knew that they intended to settle in the Cape on a permanent basis. They always knew them as temporary visitors. And so when the Dutch arrived in 1647 and in 1648, the Dutch were actually welcome and given food. The one thing that the Dutch were desperate for was meat. They wanted meat, and then they wanted labor. They wanted people to help them to work. Their primary source of meat were the cattle that were given to them by the local people. At a certain point in time, the Khoi refused to trade in cattle because they realized that the trade in cattle was an endless, unfair bargain. It was a trade over bracelets. It was a trade over mirrors, over shiny objects that initially they thought they were interested in. But as they realized how valueless these items were, they began to resist. But that resistance was then met by guns, by force, by violence. And they were compelled to engage in these forms of trade. Throughout the second half of the 17th century, the relationship between the Dutch and the Khoi was characterized by this asymmetry in the bargaining position. Trade gave way to war, to violence, and cattle were taken by force. Such that there's a story of 1699 where one of the Khoi chiefs refused to trade. But he then makes the point that if I don't trade, I know what will happen when I get back. I will be thrown into a dungeon. What had happened basically was that a dungeon, a pit, had been dug up by the Dutch. If a Khoi chief refused to exchange cattle, they would be buried into the pit and beaten up. Some of them would die in the pit and others not. So it's that relationship of cattle trading that ultimately breaks the backdrop of the Khoikhoi society. Now, when I was a child at school, what I was taught in my history class was that the reason white people have so many cattle and black people have so little is because the black people gave away their cattle to the whites for mirrors, for bracelets, for glasses. What I never knew, which I've only begun to appreciate now in my adult life, was the extent of the extreme violence and barbarity that accompanied the entire cattle dispossession. So that when in 1713, the so-called smallpox epidemic, which is usually cited as the explanation for the breakdown of the Khoi society, when that smallpox epidemic began, it found a society whose modes of resistance had largely been destroyed. And rather than being a cause of the breakdown of the Khoi society, it was in fact the end of that breakdown. It didn't start it, it ended. Now that story of violence accompanying dispossession of cattle was to be replicated in the Eastern Cape by the British. It would also be replicated in Natal by both the Boers, the Afrikaners, the Voortrekkers in their relationship with people like Dingaan, people like Mbande. It would also be repeated by the Voortrekkers in the Transvaal. And the story is the same. And I couldn't work out in the course of writing the book, what is the full extent of the cattle losses? And the reason I got into this idea of cattle was to recognize the centrality of cattle in the African economy. You see, land could not be sold or exchanged in the open market by Black people because land was recognized as a common inheritance. But cattle could be sold. Land also could not be owned on an individual level because land was a communal asset that we inherit, we exploit, but we pass it on to generations that come after us. But cattle could be owned privately. Cattle were the mechanism in which we established relationships with the dead. When you want to perform a cultural event, you want a spiritual connection with a world you never inhabited. It is cattle that form that spiritual connection. Cattle were mechanisms to establish friendships with strangers. A man who wants a wife exchanges cattle with the family of the woman. Cattle were a form of peacemaking. Two tribes that are engaged in war, they sue for peace through the mechanism of cattle. So if one looks at the centrality of cattle in the ways in which Black society was structured, it was the taking away of those cattle that not only brought about extreme levels of poverty, but they also brought disintegration in the political and social and economic structures. And they also brought about this idea of wage labor. And so later examples, like Cecil John Rhodes passes the law in 1894, the Glen Gray Act, in which there is a restriction to land ownership. Black people could only own a certain piece of land. It was called 1 man, 1 hectare. It necessarily resulted in the reduction of the number of cattle that could be owned and kept. The same thing that happens when the 1913 Native Land Act is passed. One of the Black lawyers that I wrote about in my first book wrote this provocative, thought-provoking piece in 1918. His name was Richard Musema, in which he says that it is wrong for people to perceive the 1913 Land Act as an act of dispossession of land. Rather, it is an act of dispossession of assets, of labor, of cattle, of farming tools. You see, if you look at where did the whites begin farming, you have to go back. You mentioned the year. You have to go back to 1665. What you get there, you get a resolution of the Dutch East India Company, its managing board, the Council of 17. It passes a resolution that says the free beggars, in other words, the whites, the farmers who wanted to leave the control of the Dutch East India Company, could get free land. They could get free slaves, or rather enslaved people. They could get free farming implements. They could also get a guarantee of the market. The company would buy their products directly from them. And they don't have to pay back anything. The only guarantee that they needed to make was that the cattle that they would be using would be acquired from the farm. They were even exempted from paying taxes. And that's the beginning of the so-called prosperous farming community of the Cape. If you fast forward 300 years later, 1939, they introduced the so-called betterment schemes. The betterment schemes are all about a criticism of Black people who are not using the land optimally, but rather they are accused or criticized for bad farming practices. What is the solution? The solution is, again, let's reduce the cattle. You go to 1949, a proclamation passed a year after the National Party came into power, which is again about betterment. It results in the conflict at Witshoek. It results in the so-called Pondo Revolt. So over a period of 400 years, you've had phases of intense and violent dispossession. And so we then begin to debate today in this generation ways in which we can live with the dispossession and ways in which we can undo this dispossession. And so it's in this larger historical context that one always approaches the issue of land. Of course, in the book, I cover other facets, women, and other facets. How does one deal with the crimes of apartheid on a comparative basis? What have other countries similar to us, what have they done with inheriting legacies of intense forms of dispossession? Not dispossessions that have happened and stopped, but dispossessions that are ongoing. So you will find that historical part in this book, but you will also find, as Freddie mentioned, a contemporary part. So in the last, I think, 20 minutes that is remaining of my time, I want to give a few thoughts around this idea of how to build into the structure of compensation, justice, and equity. The first thing I try to say in the book is a critique of the default position of the state. That the state's default position is to always compensate people who lose their land in exchange for redistribution or restitution or tenure, is to always compensate them at the prevailing market value. That's the state policy. It remains the policy in 2021, notwithstanding the debate we've had since at least 2018 about the unsustainability of the so-called willing buyer, willing seller. But we might nevertheless consider why compensation is generally paid. The argument often is that there should be no compensation because the current landholders are holding the land on an unfair basis. Often it is argued that the land holding is a product of a land theft. And the responses on the other side are usually pejorative and dismissive. But as I point out in the book, arguments about land theft have got validity in history. Surprise, surprise. Our history books are replete with examples of blank documents signed by African chiefs disposing of large pieces of land for no consideration, of contracts that contained oppressive clauses that were not understood by the signing party. Take the root concession of 1888, signed by Lobengula, king of the Amandebele, which is perhaps the most notorious of all of these examples. Professor Martin Legasik wrote a book called Hidden Histories of Codonia, in which he wrote about the will of Abram and Elizabeth September, and the story of the sale, quote unquote, of a farm in 1908. He shows that the signatures of the Septembers, marked with an X, were forged. Yet this is a story that is emblematic of a wider problem. On 9 March 1923, the Cape Times reported the practices of the Northern Cape, in which colored people lost their land to the whites. Colored farmers were said to be succumbing to the sharp practices of unscrupulous whites. In this respect, the Cape Times reported, storekeepers pushed credit upon them, loan agents got them involved in loans and litigation, and brandy sellers further assisted their ruin. Downright fraud, such as giving a beggar's signature to a deed of sale, represented to him as merely an option to buy his farm, was probably not often practiced. Many strategies were used. Land would be sold for an apple. Coloreds would be told that they were signing a lease agreement, and later it would transpire that it was in fact a sale agreement. Land would be taken in exchange for settling a debt. And so accusations of land theft are not as absurd as they appear. Although the majority of land theft was taken by violent conquest, some of it was taken by downright fraud, trickery, and thievery. It is true, I say, that the present beneficiaries of land or the present owners of land are not themselves directly implicated in these acts of thievery that took place in colonial rule. Those direct beneficiaries have long passed on. But to the extent that the same land that was violently stolen remains in the same family, its uses may have transformed significantly. And current holders usually denounce any association with historical violence. Take, again, another story that fascinated me when I wrote the book. Take the case of the Cape Vineyard, known as Leef op Hoop. This farm was once owned by Louis van Bengalen, Louis of Bengal, a former slave of one Zacharias Wagner, who had sold him to Hendrik Lacus. Lacus was later involved in a case of fraud, resulting in his slave, Louis van Bengal, being allowed to buy his freedom. With it, Louis could be baptized and own property, which saw him acquire 3 farms and become a successful farmer. The grant to the farm, Leef op Hoop, was signed in 1892. Louis died in 1896. Centuries later, this land would be bought by Marcus Jooste and Janne Mouton, 2 of the most successful business people in the Cape. Many people will disagree about Marcus Jooste, but he bought a farm that previously belonged, at least in the 1800s, belonged to a former slave. No doubt, both Marcus and Janne Mouton would denounce any association with the oppressive practices of the past. But the point to be made is that it may be impossible to draw a straight historical line between current possession and the first act of theft or deceit. But that does not mean we should ignore the historical evolution of the land story as a whole. What adds into the complication is that land has also become part of a larger global economy. Products like wine, maize, and wheat may be produced locally, but they are traded internationally. So the world we live in is no longer the same world that Van Riebeeck inherited, nor is it the same world that even someone like Nelson Mandela inherited. So the larger point to be made is that the compensation dynamic is not a simple equation of looking at a past injustice with an injustice of today. What it requires is a careful balancing of conflicting, overlapping, and sometimes complementary consideration. One of those is that expropriations should not cause inefficiencies. Land that is currently being used productively should not be taken if its reallocation would make it less productive. But this too may be a complicated view. Who decides what is an acceptable use of the land? The state may consider it appropriate that land being used for farming should instead be used for residential purposes. The farmer might regard that as inefficient, but it is clear that the shack dwellers who receive a house each would regard it as extremely efficient. So then, why then should we pay compensation? I think that the strongest argument for paying compensation is to spread the cost of the expropriation. If no compensation is paid, the owner bears the full cost of whatever the public purpose is being served. But there might be another reason why compensation is paid. In the book, I make the example by reference to the people of Codonia. If those of you don't remember the brief story, a mining conglomerate from Australia wanted to mine titanium in the Eastern Cape. The state gave it the license, but it could not mine without displacing the local community. And under the law, the MPRDA, it was entitled to ask for the displacement of the community. But this displacement was resisted. One possibility, therefore, that presented itself was that the state could expropriate the land. In a no expropriation setup, the state would be entitled to pay no compensation to the Codonia community. But would this be a just and equitable outcome? Many people would argue no. And if you ask them why, they would say that you have to look at the historical context. And I agree. But it shows the larger point that a winner takes all, no compensation regime always ignores a situational analysis. So the reality is not that we are dealing with a dynamic of no compensation versus full market compensation, but rather, how do we decide a just and equitable form of compensation? This is where we have failed since 1994. We have designed two methods primarily. There is a range of other methods that I've dealt with in the book, but we generally apply two methods. The first is where we redistribute land, we apply the so-called willing seller, willing buyer. Everybody knows the flaws with that method. And in the restitution context and labor tenant claims, we tend to apply the so-called Geldenis formula. This is a formula developed by Judge Anthony Geldenis during the time when he was a judge of the Land Claims Court. Its basic framing is that one should start by deciding the market value and then apply other factors in section 25.3 to adjust the value upwards or downwards as may be necessary. Now, the criticism of this formula is quite obvious. it privileges market value above other factors. But it also is a mechanical formula. So I then argue in the book that we should make an explicit break with willing seller, willing buyer. We should consider that in any event, a market-based approach for expropriation is an artificial concept. Remember that a market-based system, a willing seller, willing buyer, works on the theory of a willing seller, a willing buyer, an open market, and an arm's length transaction. We have none of those factors in an expropriation setup. We do not have a willing seller. An expropriation, by definition, is that the seller is compelled to sell. We do not have a market of buyers. There is no competition for price. There is only one buyer, usually the state. We also do not have an open market, nor do we have an arm's length transaction. So then, why have we been bothered with a market-based system in expropriation contexts? This is an interesting phenomenon for me, because in the historical researches that I have done, it is quite clear that in the early 20th century and in the late 20th century, both the colonial and apartheid judges always thought of a willing seller, willing buyer in an expropriation context a little bit of an anathema. They always thought that this, in fact, was a fiction, and therefore never actually applied it. So what we have had is we have had, in a post-apartheid setup, a rigid system that continues to privilege white landowners. Now, and this privilege of white landowners is not only in the compensation setup entrenched in policy, it is also entrenched in practice. 4 years ago, at a conference, I asked the then Minister of Land Affairs how much money the state had paid for land reform since 1994. The figure is 60 billion, 60 billion. I asked her who, in fact, had benefited the most. She responded that the majority, and I subsequently established the figures, are 60% of the beneficiaries have been white landowners. So we have an odd outcome in which the policy, the stated policy, is towards redress, but the practice is the continuation of apartheid policies. And the biggest beneficiaries of land reform have been white landowners. I've shown in the book that part of the problem is a policy problem. Landowners control the entire value chain of land. How? They decide which land is put to the market for sale. The land that we buy in this country is bought primarily by sales, either privately or public sales, or it is bought by auction. Whether you buy it by sale or by auction, the person who decides which piece of land should be available is the owner. Landowners also decide the price. When they put the land up for an auction, they set the reserve price. When they put the land up for an open sale, they put their own price. Landowners also decide what the land is used for. It's a crucial point you must remember. They decide what the land is used for. So if they have a choice between selling grazing land versus selling productive land. They sell grazing land. Stellenbosch University recently published their research, which showed that 99% of all land acquired by the state since 1994 has been grazing land. It's been just open pieces of ground. It has not been the food producing land that state policy speaks about. The reason why this is so is because there is a complete control of the land system, whether it's redistribution or restitution or tenure. That land value chain is completely controlled by white landowners. No wonder the outcome is the way we have seen it. If you want serious reform, you have to start by breaking the land control over the value chain by white landowners. It can only be broken by the state. Then the last thing I want to say in the 5 minutes remaining of my time is the prospects for no compensation or nil compensation or zero compensation or without compensation, whatever formulation. In the last conference that I attended of the BMF, I spoke of 3 possibilities for achieving no compensation. Now you will recall that my own view is that a winner takes all, one size for everything, no compensation system does no justice to history and does no justice to the future. The future lies in the flexibility, in the situational analysis, in the context-specific analysis. One of those possibilities to achieve a no compensation for certain contexts, not for all contexts, but for certain contexts, is a direct amendment to Section 25 of the Constitution in order to make explicit that land may be acquired by the state for wider public interest goals without compensation or with zero compensation or with nil compensation. Now, the prospects of this possibility are diminishing every day. The reason for the diminishing prospect is political disagreement over the formulation and over additional aspects, such as whether or not there should be state custodianship over land. Those are causing this possibility of a direct amendment to look more and more remote. That takes me then to the second possibility, which I was a proponent of at the last conference, and I'm still a proponent of, which is the passing of legislation, such as the Expropriation Act, to replace the 1975 Act, in which there is an explicit statutory clause that mandates expropriation without compensation in certain instances. But those instances ought to be clear. They ought to be subject to judicial review. And the third instance, less promising, but nevertheless possible, is an ad hoc judicial decision-making in which, on a case-by-case basis, the judges decide that a particular piece of ground at a particular time to a particular owner does not warrant compensation. When I was an acting judge in the Land Claims Court, I began to move away from market-based compensation. Most of you who have been following the judgment of Musema know that I was subject to criticism in the Supreme Court of Appeal. But nevertheless, what it shows is the inexact nature of the text and the possibilities of what can be achieved within that inexact nature of the text. So where do we go from here? I think 3 things that I want to say. The one is to broaden the discussion about what exactly are we trying to recompense or compensate. I think that using the lens of land is a very narrow way of looking at what was lost. We need to broaden it to think about the economy. Perhaps it is the economy, it is the mechanisms of independent economic living that were lost. Should we be looking at reparations? The debate on reparations has been abandoned, but it is perhaps time to reinstate the debate about reparations. Secondly, we ought to move with speed on the debate on the amendment of the expropriation bill and passing it. That bill contains numerous problems, but it is a promising start. Thirdly, we have to fix the structures. Our institutions do not work. The Land Claims Court is a very weak court with no permanent judges, functioning primarily through acting appointments. The Land Claims Commission is also a weak institution with a high level of vacancies and chronically underfunded. So the idea that you can have an agrarian revolution with institutions that are as weak as we have illustrates a disjuncture between rhetoric and practice. So there is a possibility for the future, but it can be constrained. The question is fighting against those constraints and always remembering the significance of law. In the last part of the book, this is how I speak about the law as underpinning transformation. I say that the ability of the rule of law to deliver justice is severely stretched in the debates for the return of the land. No one really says that the land will come back via the law. But at the same time, arguments that question the utility of the rule of law in the struggle for the return of the land overlook the centrality of law during the struggle against apartheid. Apartheid was not defeated by law, but law was nevertheless central in its defeat. But here I also mean that the struggle itself was also for the law. Our forefathers were in the struggle so that we could have access to the law. They used politics, they used violence, they used the courts. But they were not fighting for the vote alone, nor were they fighting for the return of the land alone. They were also fighting for the law. Hence, we cannot abandon the law. We need the law to define our rights. We need the law to set the limits on government action. But we do not need just any laws. We need laws that embed justice, laws that correct the past, laws that secure the future. And it is this version of the rule of law that we should continue to struggle for. Thank you.
Oh, thank you very much, Advocate. Wow, that was a lot to unpack. That was a mouthful, but it was very comprehensive. The only thing I have against you is you did not touch the issue of land that is in the hands of traditional leadership, and whether that should be part of what needs to be redistributed, or whether that is already distributed in a satisfactory manner. So I just want to touch on that, and then we are going to open up the floor for questions. There are two ways that I would like you guys to participate. The first one, you can raise your hand, we'll acknowledge you, and then you can pose your question. The second one is that you can chat, you can use the chat to pose the question that you want to pose. We may not be able to interpret it the way you want, but we will be able to read it and put it on the floor. If you feel it's not answered, you can give a follow-up question. But Advocate, please go a little bit back. Let's touch on the issue of land that is in the hands of the chiefs and what should be the way forward with regard to this. And anybody who has questions, we can just prepare. I will just come back after you just touch on that last point. Thank you, Advocate.
Thank you very much. Yes, I do have, as of those of you who have read the book and those, even if you haven't, but I have spoken about what I call chiefly power in one of the chapters, but it also comes through in various other parts of the book. So again, always the starting point is a historical starting point. The most useful starting point with the issue of chiefs is 1927, when the passing of the Native Administration Act and the setting up of traditional institutions that fall under governmental control, with the Governor General being described as the supreme chief of all natives. Remember, the Governor General was the person in charge of the country who then in turn reported to the Queen of England or the King of England, as the case may be, before South Africa became a republic. So the effect of the Native Administration Act was then this reorganization, this disruption, sometimes the creation of chiefly kingdoms or tribes, and sometimes the destruction of certain tribes. In order to make it work, to make the native administration system work, certain powers had to be assigned to chiefs. Now, in the book, I've gone back to the time of Theophilus Shepstone as a predecessor to the Native Administration Act. And one of those powers that were then assigned by statute to chiefs was the power over land. It was the power to allocate land, the power to administer land, including the power to eject people from land. There were many people that became victims of the ejection from land through what I've called chiefly power. In some communities, chiefs did not have the power to administer the land. Even if they did have the power to administer the land, it was a very restricted power. It did not include the power of eviction or the power of ejectment, but it was imposed on chiefs. Why? The explanation for it is that the entire colonial setup needed a mechanism of controlling the large numbers of natives or Black people. And this is what Mahmoud Mamdani has called indirect rule. So the instructions would come from England to the Governor General. They would then cascade to chiefs that they had appointed, or even if they hadn't appointed the chiefs and the chiefs had been the product of community participation, they were under the control of the state. So you had both of these elements in practice, one being the power of chiefs over the people, the political control, and then the power of chiefs over the economy, but that was through the control over the land. This is what the Constitution then intended to resolve. It intended to reallocate that power from bottom up. One of the unique attributes of the system I have described was the setting up of the Ingonyama Trust in 1993. I have dealt with that in the book. But the features, even if that was not the intention, the features of the Ingonyama Trust completely meet the understanding of indirect rule, where you have Ingonyama being a trustee, and where you have the community not having any ownership rights, and instead having occupation rights, which are wholly dependent on this trusteeship that has been developed with the chiefs. This has resulted in several conflicts across the country. Take my example of Olobe, which is in the Eastern Cape, or you can go to the Northwest, or you can go to Limpopo. But in every place where there are minerals involved, a mining company cannot mine or cannot apply for a permit unless it has obtained the consent of the community. And often mining companies obtain this consent via the chief. And often the chief hasn't got a mandate from the community, or often the chief is acting in conflict with the community, but is able to give away the land. In the Codonia case, the evidence showed that the chief had been bribed by the mining company in order to sign the lease agreement. The same situation at Ingonyama in KZN, in which the chiefs conclude lease agreements, commercial lease agreements over land that belongs to communities, and they collect the rentals themselves. And they took it a step further, and they started converting even the rights of occupation of the indigenous communities into leasehold, with rentals paid to the Ngonyama Trust itself. This is the type of conflict that the Constitution intends to resolve, but it is unable to do so. Several questions arise. One is, who should own the land in which is customary land or indigenous land? Who should own the land? Secondly is, how should that land be administered? Thirdly, how should commercial activity over the land take place, under what rules, under what dispensation? On the ownership question, there is a most fascinating judgment in which I acted for the community, delivered about 3 months ago by the KZN High Court, in which it says the ownership belongs to the community. The chiefs are holders or trustees for and on behalf of the community. And as trustees or holders on behalf of, they have no rights to conclude leases. They have no rights to evict people, and they have no rights to impose rent collection schemes over those people. The ownership itself is bottom, belongs to the people themselves. How should the land be administered? The judgment suggests that the top-down administration is not part and parcel of custom. The top-down administration is a colonial invention. The idea that the chief holds all power, the Shakan idea. It is a Theophilus Shepstein construction. That the actual power is bottom, it's the community. And so the land ought to be administered in accordance with the rules designed by the community. How should commercial activity take place? It should take place on a consensual, remember the phrase, free, prior, informed consent. And it is in this phrase that another critical element is located. Free, prior, informed consent. Who consents? A community often could have a meeting and pass a resolution by 51%. But the doctrine of free, prior, informed consent means even that decision cannot be applied unless the family, who are the true holders of land rights, consent. So we're talking about cascading decision-making at a family level, so that there are real rights that exist at a family level. That, for me, is a promising future. For chiefs, it is a difficult one because the loss over the control of the land threatens political control, but they ought to be thinking about it in creative ways. After all, the Zulus say, Inkosi, Inkosi ngabantu. Thank you.
Wow. Thank you very much, Advocate. You have definitely covered that part. Just before we dive into the question, I see there's a few that are already being posted. I see hands are going up. I see that the provincial leadership of BMF has joined us now. The chairperson of the province, Mr. Ndlamlenze, is here. I just want to acknowledge them. Mr. Thabo Mutaung, the deputy chair, is here. Mr. Mkolisi Mtungwa, the treasurer, is here, and Mr. Vusum Kachwa is here. Ms. Letabo Tima, MP's Young Professionals, is also here, and I see that from Secunda, there's Mr. Betwell, who is also here. So I just want to acknowledge them as the provincial chair of the hosting chapter of BMF for this particular launch. Yeah, but advocate, here we are. Thank you for that clarity. I see that I will start with the hand, and then after the hand, I will then go to the chats that are there. So I just want to see, I've got Mr. Chumampono is here. His hand is up. So Mr. Chumampono, I recognize you. Please pose your question.
Thank you, Chair. Just to pose a question there to the advocate. We have been looking at a land dispossession from a white to black context. But coming from an aristocratic family myself, an African one, I know that there are a number of cases where you find that black tribes or black nations invaded lands of other nations and dispossessed them, or of other tribes or of other clans or families. Now, looking at this context, do you think that this is a problem for government to solve? Or what do you think is the approach to that? Because I know that a lot of initiatives have been taken. If you look at the Nhlapo Commission to establish who are the rightful kings, who are the rightful chiefs, and all of that. Some of the kings or chiefs, kings and chiefs, of course, not being the same thing, but some of the kings or chiefs lost the land through war, and other families gained the land through right of conquest. What would your approach to a situation like that be? Do you think that is a governmental problem, or it is a problem of that specific nation? And if it is, how would you suggest that they solve it?
Yeah. Yeah, thank you. Yeah, I mean, you know, I don't think that this is a big problem for South Africa. I've touched upon it a bit in the book. What had happened, I mean, the way in which I dealt with this is that in 1997, the government passed a white paper on land. It then sought to explain why we had the 1913 cutoff date, why we couldn't go beyond 1913, of which I'm actually a critic of 1913. I think it's a completely arbitrary and artificial date. I think there are many strong dates that should have been considered. But nevertheless, so the government said, this was Mbeki's government, that we cannot go beyond 1913 because if we do so, we will open up a can of worms because there would be intertribal conflict. But I don't think there is enough evidence of this intertribal conflict on a wide scale. I don't mean that at a particular point, at a particular time, you know, there wasn't a tribe that invaded another tribe. But I think if you look at the impact of 1652 and the impact, I mean, that's Van Riebeeck, and the impact of 1820, which is the British settlers in the Cape, those are not comparable with any Black experience that existed prior to that at all. Even if you look at both Northern, Eastern, and Western Transvaal, the arrival of the British and the arrival of the Voortrekkers, the level of cruelty and the level of dispossession, those are just not comparable whatsoever. Now, what do we do with this history? Because that's still your question. In the areas that I have studied, both in the Eastern Cape and Zululand, what you actually do find is levels of accommodation and cohabitation, flashes of war, but not large scale decimation of communities like, someone like Smith wanted to do in fact, he said from the Cape to Natal, he wanted to kill everyone that was there. So you find flashes of conflict, but ultimately accommodation and coexistence. And that seems to have been the larger trajectory of native tribes, if I can call them that. So that's why I don't think this is a big problem for South Africa. It's often used, it's the same, these ideas of First Nations, the Khoi were here before us, and then we came late, and how can we want to own South Africa? But all of that is just completely historically dubious, right? Everyone knows this to be historically dubious. Now, yes, what is the solution? I mean, one of the solutions is the Nhlapo Commission, but you remember that the Nhlapo Commission is not a land commission, it's just a chiefly commission. It works on the assumption that chieftaincy is linked to people, not that chieftaincy is linked to land. So that's a crucial thing, is that even if you left your area, but you still had a chief, that person is still your chief and they can still be recognized as a chief. It's not an instrument to return land to a specific group of people. So you still say, well, is there a way in which we can design a system that resolves dispossession that happened by sort of a tribal conquest? Yes, one of them is not to look at land restitution only from a historical perspective. It is to look at it from a future perspective. And the most promising program there is land redistribution, which says we cannot fix all of the problems of the past because we don't have, in 1913, I think in 1913, there was something like 13 million people living in this country, 9 million of which were Black. That's 1913. That's when we had the 1913 Land Act. Now we've got 58 million people living here. So we cannot actually resolve a 1913 problem. We've got to look at the future. So what is that way of looking at the future? So the one way of looking at the future is a redistribution model. And the redistribution model, what should it be based on? It should largely be based on need. And so people should be allocated land based on current need. So history may be a factor, but the predominant policy that the government ought to take right now is allocation of land based on need. So what you won't have on the scheme that I'm proposing, you won't have, let's say, so which tribes really experienced violent disruptions? So you can take Amahlubi, good example, Amahlubi. That's an 1873 problem with the arrest and detention of Langalbalele and the complete disintegration of the tribe. And we know precisely where they were between KZN and the Eastern Cape, but they are spread all over the country right now, And so the idea that you are going to reconcentrate them in that geographic area is an unrealistic idea. But the idea of a form of compensation for the future is a possible idea. But then it applies to the Zulus as well. It applies to the Swazis as well. It applies to the Xhosas as well, to the Tswanas as well, etc. And that's why I keep coming back to this theme in the book that we've got to look, this is called the road ahead. We've got to look at the mechanism that factors in history, but is not itself a slave of history.
Yeah, thank you very much, Advocate. I'm going to go to Ramahwale Mampolo. Before that, I have two questions that I just want to take from the floor. The first one is, given the current state of our government, given the collapse of almost all the parastatals, is it realistic that we have capacity to be able to champion this redistribution without collapsing even that aspect of our economy even further? Number two, I've got another question here. It says it's from, just want to see who it's from. It's from Lindani Ngumalo. And he says his interest is with the urban land for human settlement and development. With the alarming rate of land invasions that we see, where people illegally occupy land, be it municipal land or privately owned land or land that belongs to one entity or another, how this is essentially dire, what he says, for the indigenous people to have an equitable access to land, specifically those seeking economic opportunities in urban areas. A lot of the time, this particular crisis, you will find that people invade uninhabitable land, where that land is lying in a low-lying area, maybe where it's prone to flooding or other things. And we then have a problem that when these things happen, when there's an abundance of rain or the climate is in another way, then we see that the community is left in dire situation. A lot of the time, those land invasions happens with an illegal occupation. And sometimes if we are towards elections, one constituency or one political party will deem that as its constituency and say, go and cast your ballot, we will declare this township and we'll establish this township, and it will become an established township so that you can be able to dwell in it. So how do we address this land grab situation that we have? Before you answer, Advocate, I just want to Ramakwa Mampulu to come in and pose their question so that you can then address all of the three questions. The capacity, is it there in our government, given the state of our parastatals and state-owned entities, the issue of land grab and invasion by community seeking employment in urban areas, and Ramakwa's question. Go ahead, Mr. Ramakwa.
Thank you, Program Director, and want to acknowledge the good session that you are hosting and applaud and appreciate the wisdom of Advocate. We are really honored to have you. I've got two questions that I want to pose. The first one, you raised it during your speech, that most of the land that was bought was for grazing land, low potential for niche products that dominate the economy and the market and are used on a daily basis. What mechanism can be employed so that then the high potential agricultural land is redistributed to a capable and needy, previously disadvantaged Africans to be able to partake in the real economy? Because we are set for a failure, that we are given a very marginal land, marginal in a sense that it will be shallow in depth, because if it's shallow in depth, it means limited crops will survive in that area, or the climate is not feasible in terms of the rainfall and the temperature to grow the crops. We need to find mechanism, because without addressing the real economy of agriculture will always be dualistic in nature, and the concentration will always be dominantly from the white commercial farmers. The second one, it will be, given that state is still using the Provision of Land Support Act 1993, you could see that there is a limited capacity of government to reform legislation so that they are geared for the current scenarios to address the issue of land redistribution or redistribution or tenure, because redistribution will not necessarily be accelerated with acts that were framed in 1993 and in 2021. A lot has been changing with climate change, but also with what we have been using, the models that has been there, either willing buyer, willing seller, or blanket approach to all needy people. What is it that the lawyers, the legal fraternity can help to deal with support of drafting of legislation and support the political parties, both the ruling and the oppositions, to have these bills that will give us a meaningful change? Because without statutory provisions, we will argue about this, about that, without real things that can really guide us. And the law is very key to this effect, because a lot of inconsistency and incapacity emanate from guiding legislations to accelerate land redistribution. Thank you very much.
Yeah, thank you. Look, this is excellent. I mean, both of your questions are absolutely excellent. Yeah, it's just great, both of them. I think to start with the last one, I mean, this is one of the critiques I've put in the book, that the idea that you can do redistribution through the provision of Land Support Act of 1993, is unrealistic. And you say it's a legal problem. I think it's a political problem because lawyers don't really initiate legislation. Politicians do. What do we need? We need a redistribution bill. We need a redistribution act. We should have passed this. We spent a lot of time on the constitutional amendment, a lot of energy. And the way things are looking right now is that there will be no amendment, because in order to effect an amendment, you need a 2/3 majority. And it's looking right now that there will be no 2/3 majority. But the energy that we have spent in the past 4 years on this issue should have gone to two things primarily. One is a land redistribution bill, in which the control of private landowners is broken by the state, in which there is a clear policy of who benefits from land redistribution. One of the problems we have in this country, nobody knows who gets the land. We have no policy of who gets the land. The result is that PLAS, PLAS, the association at UWC, did this amazing research in the Eastern Cape, in which it showed that people who get the land are people with political connections with the ANC. It's the elites that are getting the land. They have no interest in farming. They have no skills to farm, but they are front of the queue for land redistribution. So the Redistribution Act is urgent, and it needs to address two things: is how do we break the stranglehold of landowners, and who benefits from land reform? We haven't got those things addressed, and we are moving ahead with a lot of speed, but with a very little insight into where are we going. We're going to pass the constitutional amendment on expropriation. Question is, how do we get the land and how do we distribute it? Those two questions remain unresolved. And that's why your question is so brilliant. What can we do now as lawyers, because we don't control the political process? I think what we can do right now is to bring a constitutional challenge which says the conduct of the government in running with a system in which it has no redistribution framework is unconstitutional, because it's a compliance with Section 25(5), which imposes an obligation that they should take measures to make sure that there is availability of land on an equitable basis. They haven't got a single piece of law that implements Section 25(5). And even this entire debate, which has been about Section 25(2)(b), one section, it's taken us 4 years, one section. It doesn't touch the core of land transformation, which is 25(5), 25(6), and 25(7). So there is a clear constitutional gap right now. A lawyer wants to bring a case. It's a case to say that the conduct of the government in failing to pass a law to give effect to Section 25(5) is unconstitutional. This was done in the context of political party funding, where an NGO went to court, eventually at the Constitutional Court, and said that the non-regulation of political funding by law is unconstitutional. We now have a law. So that we can do right now, but this is ultimately a political problem, that we just have a state that's moving ahead, but it has no way of defining what that ahead is. So yes, I mean, thanks for raising this point. In fact, I should have made this point in my opening remarks, because this is the future of this country. It's the redistribution of land. The first part of your question, which is I mean, again, it's a wonderful question, because we keep talking about land, but the actual facts show that the land we are getting as the state is not food producing, is not high agricultural potential land, it's grazing land. The reason why we have that is because there is a complete landowner veto in South Africa, a total landowner veto. Right? The idea that they decide which land, what is the price, what is the use, and who are the beneficiaries. So breaking the land ownership veto should also be a function of the Redistribution Act. Right? It's breaking that veto. There is no way you're going to ever guarantee that the land that is made available is food producing land. It's high agricultural value land. You are always going to have the 99%, which is grazing land, because the entire land value chain is controlled by an elite land owning class. And so breaking that veto is the key. One of the key points that I make in the book is that unless you break that veto, you are actually going nowhere. The other 2 points that have been raised, I mean, I agree with this point about the collapse of institutions, right? And it is a major worry of mine, is that what we have, I mean, again, we've spent 4 years on this discussion. We have not been building the institutions. We've not been building the Valuer General's office. We've not been building the commission. We've not been building the land claims court. So you then wonder, you know, like all of these ideals that we have, what is the institutional mechanism for giving effect to them? Instead, we've actually allowed them to decay. The point about land occupation, you know, I mean, I'm not as critical as many people are on land occupation. I think the philosophical point to be debated on the issue is, who are the drivers? Who is driving development? If you're waiting for the state to drive development, right, you are going to wait for a long time. But the private sector in this country has been driving development, which means that land ownership patterns follow the trajectory of the designs of the private sector. But the people, the communities have not been driving development, right? It's been driven by the private sector. This you can see for yourselves. I mean, just go to Fourways and see the large developments. Who are driving them? It's the private property developers. Those are the people driving development in the country. We need to shift the location of the land development agenda from the private sector to the people. So sometimes people will occupy a piece of ground, not so much because it has developmental potential, but because it's available, right? And they do not have the wherewithal. But it's often through those sporadic occupations that you actually get development, in situ development. Toilets are built, right? Water is installed, electricity is installed, you know. So I'm not particularly opposed to people, in a sense, I mean, taking their future in their own hands. Because I mean, waiting for township approvals by the government, I mean, we know the consequences of that. And we also know areas like Joslovo and Port Elizabeth, elsewhere, that we've had those large township developments as a result of a people-centered and a people-driven, you know, trajectory. And so that for me is the larger philosophical question, is what is the locus of development? If we allow the locus of development to remain with the private sector, we must accept the continuous conflict, and we must also accept that the people themselves will occupy whatever land is available. And when they do so, stun grenades and rubber pellets are not the answer. You know, the answer might be, well, let's just put in the water because that's where the people are. Thank you.
Thank you, Advocate. Two questions. One is, can you clarify what you mean by break this veto? How is this done practically? I think it's a very important point. The other one, Advocate, is with what we have seen in the last couple of weeks with the unrest and the rioting that was there, there was a sense that comes out of the entitlement mentality that South African has, which kind of seeks to assume the identity that every South African is owed economical participation, or rather every South African is owed economical benefit, even without participation. Now, how do we deal with this issue of redress and redistribution while at the same time being mindful of this particular dysfunctional culture which we have, taking into account the successful scenarios of places like Rwanda, how they've dealt with their issues there, even coming out of the ashes of war. So how do we come back as South African and deal with this issue of redress while at the same time breaking the cycle of entitlement that we have as a society? So just that one, and then the one from Kirsten Stern, which is, how do we break this veto? Thank you, Advocate. Back to you.
Yeah, thank you. Yeah, I mean, I think again, the point about breaking the landowner veto, I mean, this is a crucial point. I mean, it's again excellent. Yeah, you know what I mean about the veto. I've drawn the scenarios about what the veto means. You know, now, where have we seen this veto not being exercised? It's only been in the restitution context, as well as in the labor tenant context. And why? In the restitution context, the driving ethos is historical dispossession. So I show that in this particular ground, I lost the land or the right to the land after the 19th of June, 1913. And ipso facto, I'm then entitled to get it. So that decision is not a decision that is to be taken by the landowner, but it is a decision that is prescribed in legislation. And the location of the land can be anywhere. But even on that issue of restitution, where a prior decision is located in a legal provision, what we've found is that there are elements of the veto that frustrate the exercise of that redistributive or restitutionary ethos of the Act. Because one of the points that they will make, particularly in relation to urban claims, the majority of urban claims, I think the numbers I put in the book is something like 95% of all urban claims were resolved by money. You know, people were just given cash compensation, which was very low. I mean, at the time, it was the equivalent of a housing grant of 30,000 rands. So you had land in, you know, Mamelodi or elsewhere, but it's classified as urban land. You want the land, what you get 30,000 rands, you spend it within a few months, and then you come back and stand in the queue for RTP and say, well, guys, I actually want a house. Well, but we just gave you money, but well, thanks, but I still want a house. So those are the two areas in which the veto has not been able to be exercised in full. But the reason it couldn't be exercised in full is because legislation locates the decision-making power to the state. So the way to break the veto is locating the decision-making power to the state, not enabling or allowing landowners to decide which land, and this is the most crucial decision, is they decide which land is made available. So the state needs to be driving these decisions, and it ought to do so not out of its own arbitrary contemplation, but driven by the needs of the community. So the communities ought to say themselves, this is the land we want, these are our needs. and the state plays the administrative and adjudicative role. So I'm arguing for a developmental philosophy that shifts from private landowners to the people, but that facilitation can only be done by the state. Now, I'm not here saying the state needs to own the land. I think that is a dangerous thing. But I think that the state needs to play a much greater role than it is currently playing. The idea that it basically is hands-off and says, well, the rich people with the landowners must drive the process. That is precisely what it has taken us to right now. And there's a second point to be made about this. Often critiques of the arguments that I make, I was very pleased to hear that actually a lot of them have now bought into the arguments because they were positive about my book in the reviews you read. But often critics of the arguments that I make say that we need the market to drive reforms, and that if we give the state the power to drive reforms, what we get is statism. But the counter to it is that it's precisely because we've had an unbridled market-based system to land reform that we have got to the crisis that we are in right now, because the state is hands-off and it's the market that is driving land reforms. All right, so I mean, the entitlement issue, I mean, I don't know about entitlement. I mean, often, this is used in a very pejorative way. The entitled, are the Black poor, that are in the villages and in the townships. They are the Black poor, they are unemployed, and they are classified as entitled. They want the state to give them grants. They want the state to give them jobs. They want the state to feed their children, etc. But that is a construct. It is a construct. And who does this construct actually benefit? The construct benefits the elites, because the elites do not like the disruption in their modes of production and accumulation. Yet, who in fact supports the lifestyles of the elites? It's the so-called entitled, So I think this pejorative notion that South Africans are an entitled group is not actually supported by experience. Many poor South Africans wake up every day, they try and get a job. They wake up every day, they try to go to school. They try to make their lives better. And how many people did we arrest from the unrest? 1,000 people. How many unemployed people do we have? 29 million. So there is just no correlation, between this idea that we've got these massive groups of people that are entitled versus what we see in reality. I drive every day to Sandton. As you drive up, you actually see lots of people waiting on the streets. And if you have a buggy, you can put them on the buggy. What do they want to do? They actually want to work. So the problem is not an entitlement problem. The problem is on the distribution side. It's that we've got an over-concentration of wealth. And if you are looking for where the entitlement is, it's precisely where the wealth is. Remember, these are the points I tried to make in the book. Remember what they demanded from the government in the early 2000s: liberalization, opening up of international trade, opening up the change to the stock exchange rules. What did they say they were going to do in return? They said they were going to encourage and facilitate domestic investment. What did they got? They got liberalization. They got the ability to export cash out of the country. They got the change to the stock exchange rules. What did we get in return? Nothing. We got nothing in return. So who in fact is driving the culture of entitlement? It's the super elites.
Thank you very much, Advocate. I think Nhlakani Ponkosi was asking the question about state-driven development in capacity, but just now you've addressed this issue of who should drive this. Should it be private or should it be state? So I will just give an opportunity. Is any other question from the floor that has not been answered? I will take one last hand or hands. If there is no other hands, thank you very much, Advocate, for this time. Thank you for taking time out of your busy schedule to indulge us, to dive into this book. It's more than a book. It's a subject matter that concerns each and every one of us, and it should. And it's a subject matter that has remained largely divisive of our society. And what I take from this book is how the book seeks to pull everything together. You touched on the issue of compensation not being payment, because compensation seeks to address how much this is, not necessarily how much the cost, but what would be fair and just with regard to this particular piece of land. So it's very comprehensive. It attempts to touch each and every aspect, including those that are against land reform, which is good, because at least you went ahead, of the stream in order to be able to anticipate and to counter what may come from the other side. So thank you very much, Advocate. I will hand over to the provincial chairperson of BMF in Mpumalanga. As from me, I am thankful, I am grateful, I appreciate every person who participated. My facilitation or facilitating will end here. Advocate, I will comb my hair from tomorrow. I have left it uncombed for a week now in honor of you for this. So thank you very much for it. And thank you for people who stayed the course. We started with roughly the same number of people that we have now. So it shows that we did not lose people along the way. And even next time when you write another book, hopefully it will be a successful story and not one of a failed project or a failed reform of the country. You will come back and we can launch that book on the same platform. But thank you very much, Advocate. Continue to do the good work that you are doing, knowing very, very well that we are watching the young minds that are in the legal fraternity that are here today are watching you, and they are watching others like you, because it's those footsteps which they decide to follow. And we appreciate the fact that you are taking on a lot of community-driven cases where community has unfairly been dealt with in terms of land alienation, be it for mining or other purposes. So we don't see you only in high-profile cases, but we see you in community-driven cases as well as high-profile cases. That is something we acknowledge and we appreciate, and we say, keep doing it, and may you be blessed moving forward, and may you grow beyond and past where you are right now. Thank you, Advocate. Over to you, Mr. Chairperson.
Thanks, Mr. Freddy. Advocates, it will be an injustice if we don't speak about the chapter of women within the book in relation to the month that we are in. So before I say my last parting shot, I think it's prudent that you actually speak about women's role in relation to your book. Yes, sir.
Yes, thank you. Yeah, I mean, it is one of those chapters I took, great care and pleasure at the same time in producing. And the reason actually I wrote about this is often, the Freedom Charter says that the land shall be shared among those who work it. Land shall be shared among those who work it. My own experience personally, I grew up in the Eastern Cape, in the old Transkei. It was my grandmother who worked the land. It was my mother who worked the land. It was my aunt who worked the land. They not only worked the land, but they also fed us. They paid for our school fees. They made sure we eat every day. And this is the story of every Black man of my generation. Why? Because the fathers were either dead, alternatively, they had gone to the mines of Johannesburg. Some of them were employed in Cape Town, and others were in the villages, not being very productive with their lives. Yet, as I grow older, I realize that despite the centrality of women in my own upbringing and the centrality of women in the general raising of young boys in my own community, if you look at the actual figures and statistics, who has in fact benefited from the land. On the restitution, only 30% of beneficiaries have been women. On redistribution, only 37% of beneficiaries have been women. On tenure security, women's rights to the land have constantly been trampled upon, and with a shift towards a patriarchal system. So on the one hand, there is this conflict or a tension between actual experience and formal practice. Where I started with this chapter was to try and understand this anomaly and to try and look at history. I began with the daughter of Sandile of the Ncika. Her name was Emma, Princess Emma, who was sent to school at Zonenblom by the British as a mechanism of the bridging of the cultural gap between the British and the Xhosa. They saw Emma as the way in which civilization would be brought among the Ncika. So again, we see the centrality on a cultural front. So the story of land becomes so crucial to her life at a later stage, because the British then had to decide how would her fees at Zonenblom be paid. And those fees would be paid by allocating her land in which there would be a tenant, a white tenant for that matter. And she had 2 large pieces of land, both of which were occupied by white tenants who then paid rental, which was used to pay for her school fees. But if you contrast that, this is 1850s. But if you contrast that British policy with the early 1900s, it had completely changed and women had been relegated in society. And I also tell the story of the Women of Americana, which again is a fascinating story being this month. That although in Marikana, we usually talk of the story of the men who go and work in the cities and send remittances home, the story of Marikana shows how complex that narrative is. That after a period of 3 months without wages, the men in Marikana began to depend on their women in the villages, sending remittances northwards as opposed to receiving those remittances. How did they do this? It was through engaging in farming and using the land productively. What form of land was it? It was trust land. It was communal land. And transforming the uses of that communal land then had the effect that it could generate income and it could create economic opportunities. So in other words, this is the last point I'm going to make about this because I don't want to get too taken up by it. In other words, you know the song 1985, I think it was 1985, sisters are doing it for themselves. I think it was Aretha Franklin. So women are not waiting for empowerment from men. They are empowering themselves. But the law is lagging behind and governmental support is lagging behind. But there is progress that is being made from bottom up. So these are some of the ideas I explore in the book around what women have been doing for themselves and how the law continues to marginalize and discriminate against them, and what the law needs to do in order to stop the marginalization, to stop the discrimination, and instead to embrace the development that is already taking place. So in many ways, I mean, it's an ode to my own women elders. The book itself is dedicated to my aunt who raised me, not as my mother, but she played the role of mother, you know, when I was a kid. And yet what I see in practice is the continued marginalization. And I try to grapple with that problem. Thank you. I'm sorry I've taken a long time, but you've pricked the nerve.
No, thanks, Advocate. I think from our side, it's been a dream of 4 years in working to actually get you here. I remember we once met at the forum where it was you, it was the gentleman from EFF, and Professor Lisha, where Professor Lisha would talk about the mind frame of coining this ideology of land. That also touched me a bit. But as you can see, as Freddie has said, it's been 4 years of a dream coming true, and we are very thankful of actually you coming to honor Mpumalanga and be part of us. Hopefully, we'll get you on another book, but also just to thank the audience for coming to be with us. I think it wouldn't be a show without the audience, So we are thankful to the audience for coming and grazing us. This is a kicking chapter to what we try to promote in Mpumalanga for reading. We say good leaders must read so that they sharpen their skill of thinking, and they also improve how they posture their arguments going forward. So you've opened the series, and we're thankful to that. Next month we'll have a Professor Vosi Gumede gracing the stage on a different subject as well. Hopefully you'll come on and just take him on it. He also has a chapter on land. Maybe you can give him 2 pointers there and there. But thanks to everybody who actually has joined us. Thanks, Mr. Freddy. Thanks to the BMF support structures, and also thanks to the BMF board that has also joined us. Thanks to the Mpumalanga executive that actually joined us, passing on the message. It's what's in going. We'll debate it in other forums, and also find new ways and new views on these land issues, and also look at how the merits of its economical structures and economical contribution towards our country is, or does it actually necessitate that we should be arguing, or should we be arguing different things now? Or as I put in the chat as well, or are we also arguing ancestral belief and ancestral lineages? But you also touched on the point that maybe we should fix our immediate needs instead of actually trying to do redress of historical imbalances. But we'll speak to that. But thanks again to everybody who has joined us, and we'll like to declare the session closed. Thanks, John.
Thank you.